Let's bring in our guest who is standing by, National Trial Attorney Michael Jaafar, while we wait for the defense to get started. Michael, your thoughts on how the state did in presenting what seems to be half of their closing argument for this jury?
Primacy and recency, Julia. Primacy and recency. They ended well. Their opening statement ended very powerfully, right? I mean, hey, he was on his back. He had his hands up. There was no weapon around him. And why would the defendant turn his back to the victim if he really thought he had a gun, right? Very powerful, very impactful. I think they ended well. The evidence is definitely on their side in this case. And they also have another thing on their side, which is this wrinkle zany rule in Florida, which I believe is just completely unconscionable, where you can have a 6-person jury. So the prosecution of the state only has to convince 6 people that this person premeditatedly murdered the victim, right? Palencia. So, I mean, they have a lot on their side. They ended well. Their closing argument was very powerful. I'm looking to see what the defense does. The defense obviously are going to come back loaded to bear, and they're going to use the same evidence that the state used in their favor and the defense's favor. But I think that the state ended very well, and they are off to a good start in the closing argument phase of the case.
Agreed that it was a very succinct closing argument. I'm anticipating this defense, though, because when we heard openings, the state sounded one way, but once the defense started presenting this case to the jury, it was a different ball game. So they seem, even though you mentioned that all the evidence seems to point in favor of the prosecution, some of the things the defense has been doing suggest that they are overly confident in their case. They turned down a plea deal, their client took the stand, and now we heard before closing arguments that they turned down or don't want lesser included. So second-degree murder is going to be the only homicide charge that is on this verdict form. How do you feel about that, Michael?
I think that was a gross mistake. I think it was borderline negligent. When I heard about that, before that they turned it down earlier on in the case, I said that this case screams lesser included charges, because at the end of the day, you have a person who is unarmed lying dead on a highway after cycling on the Rickenbacker Causeway. So it screamed lesser included charges. So for them to even take that off the table, they basically have put their client in a position. You're already nervous as a defendant or a defense attorney waiting for the jury to come back. You already need to use the bathroom 3 times in the 5 minutes leading up to that. Now you've literally taken your life savings. You've went into the casino. You've put them on black, right? Somebody told you, hey, you can put them on 1/3 of the board. You'll win 1/3 of the money, but you'll have a 400% chance more of winning something and not losing your money. Or you could just gamble. This is what a compulsive gambler would do. I was completely shocked. Turning away a plea is something else. But taking lesser included charges off the table, in my opinion, was negligent. If my client told me, and a client would never tell me, take lesser included charges off the table, because I've never had somebody tell me that, right? Because if they did, I'd tell them, you must be losing your mind. Why would you do that? You don't have 12 people on the jury. You have 6 people, right? You have no idea what these people are going to do. You called this man a con man, and then you killed him, right? I understand you had a reason, but at the end of the day, you don't know if the person on that jury wants to get back to their, 9 to 5 is going to believe that, or if they're going to think that you went out there ready to kill the guy, right? So I think that was terrible. I'll be honest with you. Very few times do I see defense attorneys in these high-profile cases make it what I see to be a grossly negligent mistake. That was one of them.
It's a risk. You could tell the judge knew it was a risk because, Michael, Alex Palencia can't come in to talk about what happened. But Cesar Sosa was there. He did flee the scene after that. So it took police some time to get his statement. There was another man that they were not able to interview as well. There's a gun involved. There's someone bleeding and dying. Is it reasonable that these other 2 people who seemingly were involved were not around when police did arrive?
That was a little bit disorienting to me as well, because even in the video, you could see, Palencia's hands came up, and obviously it was a little bit of a grainy video. Here's what I want people to know in this part of the country. Again, this is my favorite part of the country. I live down there. I live down there with my wife and kids. I spend a lot of time in the winter there, so I want to caution what I'm going to say by saying that I absolutely revere that part of the country. I've walked that Rickenbacker Causeway. I've walked it. I've drove it. I've rode bicycles on it. Right. With that being said, people down there have a distrust for institutions. A lot of them might not be here legally, and they might have fled for that reason, and the police were unable to, approach these people. That did not shock me that they could not do that, right? You can see the witness that did show up, and kudos to him for doing that, because we needed a witness there who was there. We needed, this trial needed it. He did not speak English, right? People in the jury will take note of that, but at the end of the day, I don't think it had anything to do. The fact that they didn't show up had nothing to do with the fact that they believed in the defendant, or they believed the defendant, or they believed that the defendant was right. They just had their own reasons to not be there that had nothing to do with the case. With that being said, I don't think it would have mattered one way or the other, because they clearly would have came in and testified the same way as Sosa, because they were friends, right? And they were riding with Palencia. So it's not like they were riding with somebody that they thought was a con man. They clearly did not think he was a con man. They were riding bicycles with them. So I don't think they would have added much to the case. Had nobody showed up, had we not had Sosa, this would have been much better for the defendant. But we had Sosa. Sosa came in and said what he said. And so I think either way, it balances out.
Absolutely, and this is another victim in the case who deserves justice if, in fact, this was not self-defense. We are going to squeeze in a break. All right, a break in the action there inside of the courtroom. Let's bring in National Trial Attorney Michael Jaafar. Michael, I noticed when he took off his headphones, we believe that he's listening to the translation of what's going on through those headphones. So the judge, who's been very keen on issues that happen inside of his courtroom, needs to stop things. Your thought on that and how closings are going so far?
I think the closings are going really good for the defense attorney. I think that this whole entire trial in Florida is a travesty of justice, that there's these time limits on the defense attorney. She's on a roll. She's doing an excellent job. But also, it also baffles me that they did not allow the lesser included charges. And also her closing argument, it sounded like a stand your ground defense motion hearing, right? But they waived. They didn't file any motions. I know he had a different attorney at the beginning of this, but they could have filed some stand your ground. That was a very impassioned stand your ground argument, right? But there was no motion in this case in that regard, right? They didn't fight it. But now they did not allow the lesser included charges, and they have a jury of 6 people. There's a time limit on the closing arguments. Some defense attorneys need 3 hours for a proper closing argument. This whole thing is a travesty. It's a farce. I'm very, very, very disappointed. This is not what justice is. It's not supposed to be convenient. It's not supposed to be efficient. It's not supposed to be set up in a way to let you get to lunch, right? I think it's a joke. I think it's a farce. I just want to state that for the record. But other than that, this defense attorney, with the constraints that she has, she's doing a fantastic job.
So Michael Jaafar with the strong opinions about how things are going there inside of the courtroom as far as procedure. I don't know if this defense attorney is going to be able to get everything in just the way that she delivers. It seems like she's going to need more time.